Materials. So, materials really have two main types of decisions. Materials are either consumed or transformed. Does anyone know the difference between those two? At your end. What would be a difference between consumed and transformed in the CRA's view?
Transformed is usually a prototype, consumed is destroyed or rendered valueless.
Exactly. So what they say is the definition of consumed, if you read their paper, is consumed means it's valueless at the end of the year. It has no more commercial value whatsoever. You're not going to put it in commercial use. You're not going to sell it. It's done. It's usually been scrapped. It's gone by now, right? So material stuff like that. Transformed is, let's say I build this prototype. Whoa, I put $250,000 in it. I still have it here. The materials are still here. I can touch them. I can move them. They're physically here. And someone may still buy this. It's not destroyed. It could be usable if I work out the kinks in it. So what they would say is, well, those materials aren't consumed at the end of the year. You still got them. They still could be useful. But we'll agree they're transformed into a prototype or a partial prototype or whatever that you're still working on. So they'll say, if it's consumed, it's your money. Here you go. Keep it. No questions asked, as long as you can prove it's consumed. If it's transformed, think of it as a loan on that money. Here's the loan on those materials, and here's the conditions. If you ever sell this or put it into commercial use, you have to pay us back your credits up to your proceeds of disposition of what you originally claimed. If you never put this into commercial production, so it eventually becomes consumed, then you keep the money. Right? So transformed, when you use the T661 line, you say these materials are consumed, they're going to want a proof that they don't exist. They don't want to see them around. They don't want to see physical prototypes, nothing. They better be gone. It's in the scrapyard. Transform means you've got a prototype right now or at end of year that you can show them, and they'll temporarily come back a year or two later, and they may ask, hey, where's that prototype from 3 years ago that you claimed? Oh, it's still here collecting dust, no problem, or wow, it's out here on the shop floor manufacturing, or we sold it for $1 million. That's a problem, okay? Because now you're legally required to tell them, I've sold something I've claimed in the past, here's what my proceeds of disposition were, and if it's more than what I had, I only have to pay back the credits that I originally had, but I would have to pay back up to my original credits. Okay? All right. So what happened here is, and they did a whole bunch of changes to the Act as a result of this case. It was just, CRA was so messed up in my view, is that the rules on materials were always easy, consumed or transformed. What happened here is Consoltex was a textile manufacturer. They ran some experimental production runs. Okay? They were accepted as SR&ED, but then they sold all the experimental production. What the CRA tried to argue, and they do this about every 10 years, and they just don't ever learn, is they tried to say, you have to take the proceeds of disposition from the sale and reduce all your costs, your labor and materials. Okay? And there's cases before that, we'll talk about cultures of the Flamme and whatever, where they try to do the same thing, and they go to court, and the judge says, where in the Act, anywhere, does it say you ever take the proceeds of disposition and net it against the SR&ED? There's nothing in the Act that even hints that you should do that. That's something, CRA just made that up. Literally, they just made this rule up. There's no in the law. And the judges will say, and in fact, that's counterproductive, because then we're only going to help the guys who fail all the time. That's not we want the odd successful guy once in a while too. It doesn't hurt. They're going to pay taxes, and that's the intent of the program. So what happened was, I thought it was very clear. What should have happened in Consoltex is the following. They had the experimental production. All of the labor costs that they had to manufacture and test it is in, whether you sell it or not. That's what the paper says. The materials were not consumed in the SR&ED. Materials were used temporarily in the SR&ED, but ultimately they were then sold and consumed in a commercial process. So the way it should have happened was labor's all in, and the way it should happen, still in this scenario, and materials are all out, because we got our money, to the extent that the proceeds covered it. If we still got lost, then sure, that's fine. We can claim our losses, or a reasonable portion. All right. So what happened here is, when they went to court, CRA, the judge said, more or less what I said. It should go, I think it should go this way. Labor all in, materials all out. But they're saying, but if CRA, if your position is it's all in or all out, then it's all in. The taxpayer wins everything. If you want to be hardcore, then we're going to give it to the taxpayer. So then CRA comes back and says, well, now we have to get Parliament to change the Act on materials, and they did all these changes that I'm saying ultimately didn't change anything. That if you understood what consume means, and transformed, and consumed in SR&ED, that they didn't need to change anything. It wasn't consumed in SR&ED. So the rules now are kind of exactly as they should have been. The labor's all in, and the materials are out to the extent that you sell it and get your money back from the end customer. Right? But there's a lot of confusion about this, the materials and sale of experimental production. All right, capital equipment. This is an interesting one. So I imagine you went through the rules today and you realize that there's certain kinds of assets that are never eligible for SR&ED. One, they got to be depreciable property. So land,